Yes.
My lords, my lady, I appear for the appellant in this matter with my own friend, Mr. Cohen.
Yes.
My friend, Mr. Brown, represents the Secretary of State.
And we have some assistance.
We do, yes. I hope that the information about that has reached the court.
Yes.
You know the situation with Miss Cohen's need for a
yes.
live transcription.
And if there's any we're in quite a large court with quite eccentric acoustics. And would you let us know if there's any difficulty, please?
I'm very grateful.
Will we need any breaks in the course of the morning to accommodate this?
I think my stenographer will let me know if she does, but I'm grateful.
Okay. Would you let us know if you need a break? All right. Thank you. So, Mr. Denham. Well, thank you very much for everybody for your hard work on this case. What an alarming amount of, quite confusing this case. Big amount of paper, skeleton arguments. We've got some more here, have we?
So two additional authorities from our side, my lord, yes.
Right. Now, have you had a chance to talk to Mr. Brown about how you're going to divide up?
We were in touch about it by email yesterday. We're obviously in the court's hands as to how to approach this. My initial suggestion was that we deal first with the narrow question of whether the tribunal erred in law, what our case on disposal would be but for the Secretary of State's powers argument, and the materiality of the Secretary of State's powers argument, and that Mr. Brown then deals with all of his case, and we then deal with the substantive issues arising from his case in reply, but that he has a further right of reply to that.
Well, I actually haven't discussed that. But that sort of sounds sensible.
I mean, the other option...
I'm sorry, we should have talked about this, but that is in fact what I thought was a good idea. I think my colleagues agree.
I'm grateful, my lord. I mean, equally, we're very happy to deal with everything in one go if the court would prefer, but...
Should we see how we go? We may.
Yeah.
The other thing is, we did think that this was, although they're going to be toing and froing, this might be a matter which wouldn't need the whole day, Mr. Dunham.
Yes, I mean, my learned friend and I think, are both in the position that we're very much in the hands of the court as to the level of detail you want and the issues on which you want submissions. I think very tentatively between us, our time estimate is probably 2.5 to 3 hours. But
that would be roughly what I think we were thinking.
Yes.
You can assume that we have read what we think are the material documents, because we may be wrong about that.
I'm grateful.
And we have a pretty clear idea of the issues.
Yes. Although I'm very grateful. Can I just address one further preliminary point about the advocacy on our side? Just on the question of if the court wants to hear submissions on the discrete issue of what it should do if it decides to remake the decision of the Upper Tribunal, that is to say our appeal succeeds and you decide not to remit to the Upper Tribunal, then our proposal is that Ms. Cohen addresses those discrete issues. I'll deal with everything else and she'll deal with those.
Okay.
And we propose, unless...
When would that be?
I mean, in terms of the scheme that I've just outlined to you, I think it would make more sense to have that as part of our reply. But again, we're in your hands on that.
Yes, well, that sounds sensible. Right, off you go, Mr. Denham. Thank you very much.
My lord, I'm grateful.
Yeah.
So, my lord, taking then the challenge with sort of leaving out of account the Secretary of State's powers argument, which complicates matters considerably, and just taking this as the appeal on which we have permission. This is really a very straightforward reasons challenge, effectively. My client succeeded at first instance on human rights grounds. He failed on his asylum claim, his asylum appeal, after some toing and froing.
Yes, you're missing out a big chunk of the story, but we've seen what happened before that. So I don't think, unless you want to say anything about that.
No. I mean, so there's the prior appeal remitted. So this is the second time round.
Yes.
And then there are multiple steps in the road to the parties both having permission to appeal to the Upper Tribunal. But by the time it comes before the Upper Tribunal, both sides have permission to appeal the respective.
It's all very unfortunate, Mr. Derek.
Yes.
Which, but that's not the focus of what you're telling us now.
Indeed.
Yeah.
So you have the grant of permission to appeal to the Secretary of State is in the bundle at 111. You don't need to turn that up if you read it. My learned friend Ms. Cohen puts in a Rule 24 notice that effectively raises grounds of appeal, challenging the protection decision. Permission to appeal is granted on that. Ms. Cohen puts in quite detailed skeleton argument, and that's at page 78 of the bundle, in which it's very clear that she is resisting the Secretary of State's appeal to the Upper Tribunal. She goes into considerable detail. And the matter then comes before the Upper Tribunal. And you also have, because of the fact that Ms. Cohen works with the stenographer, we also happen to have the transcript of that hearing, which is at the back of the supplementary bundle. And again, I don't need to turn that up at the moment, but it's very clear from that transcription that Ms. Cohen made submissions at some length resisting the Secretary of State's appeal against the decision of the First Tier Tribunal on human rights grounds. I mean, at one point, Ms. Cohen was addressing her own appeal on asylum grounds, and Judge Gleeson moved to the Secretary of State's advocate, and Ms. Cohen interjected and said, hang on a minute, I haven't dealt with my submissions on the Secretary of State's case yet, and went on to make submissions at length. And we say on the face of the transcript, it's very clear at the end of those submissions that she was inviting the tribunal to allow my client's appeal on the asylum point, but dismiss the Secretary of State's appeal on the human rights point.
Yes.
I mean, I don't think I need to take you to the documents leading up to this. If I can just go directly to the decision of the Upper Tribunal.
Yes.
If you want me to go to any of the prior documents, do please indicate. But it's a very, I would respectfully suggest, shortly reasoned document. It's at page 72 of the main bundle, the core bundle. And just working through it, just to sort of look at the structure of it, you see that at paragraph 3, Judge Gleeson says, for the reasons set out in this decision, we've come to the conclusion that the appeal and the cross appeal succeed. So it's very clear from the outset that the tribunal is proceeding on the basis that it's allowing both appeals.
And not on the basis that it's allowing one appeal and exercising a discretion to send the whole thing back without having had the other appeal.
Exactly, yes, exactly. We then have discussion at 4 to 6 of my client's vulnerability and Ms. Cohen's need for a live transcription.
Yep.
8 to 12, there's a discussion of the general background. 13 to 15, a summary of the Secretary of State's decision. 16 to 18, a very brief account of the First Tier Tribunal's decision and noting that both sides were granted permission to appeal.
A missing paragraph 17.
Yes, I mean, whether there's something that should be in that or whether it was just a slip of the key on the keyboard, we obviously can't say.
Mustn't speculate.
There's then a record of the grant of permission to appeal to the Secretary of State at 19.
Yeah.
20 and 21, a record of Ms. Cohen's Rule 24 reply and ground of appeal.
Yes.
And the grant of permission to appeal on that. 22 and 23 notes no Rule 24 reply from the Secretary of State. And in terms of the actual reasoning, that is all to be found in this very short section that begins at 24 and ends at 29. 24 says we don't need to set out the submissions in full, had access to all the documents. There was a detailed and helpful discussion provided of the reasons why this decision appears to lack anxious scrutiny. Now that, with respect to what to reason, that may be either a reflection of the submissions or a conclusion, but there's no reasoning behind the suggestion that the decision lacks anxious scrutiny, or the reasoning is too inadequate to be rationally insupportable. 25 effectively acknowledges that the Secretary of State has conceded the appeal on the protection issue. The Secretary of State has recognised that there is an error. And 26 goes on to record the Secretary of State's submissions on her own appeal. And then Ms. Cohen's submissions, which as you've seen comprised a lengthy skeleton argument and fairly lengthy oral submissions, are encapsulated in the one sentence.
15 or 16 words.
Yeah. Overwhelming. And it doesn't really capture the point with respect either. The claimant was Cohen submitted, there was overwhelming evidence for both a lack of family support and a risk of intense suffering. She did make that point, but she also made the point that on a proper reading of the first tier's decision, it was a sufficiently reasoned decision that didn't disclose an error of law, which is the key point. And then at 28, the tribunal says, given those concerns and the mirror criticisms of the first tier judge's reasoning by both the Secretary of State and the claimant, we're satisfied that this decision cannot stand. Both appeals succeed. And then 29, it has to be remitted. Now, my submission with respect is that one just looks in vain to find any substantive engagement with the submissions that were made on behalf of my client in that appeal. And that's making every allowance for the fact that one must respect the expertise of the tribunal and the reason.
Well, it's pretty straightforward, isn't it? You could describe this as a reasons challenge. It's perfectly clear that your client did oppose the Secretary of State's appeal, and it hasn't been determined.
Yes, that's exactly the point. And there's a suggestion when the Upper Tribunal go on to refuse permission to appeal. That decision is at page 65. And on page 66, paragraph 9, Judge Gleeson says the submissions now made were not made at the hearing.
Well, that's wrong.
Yes, it is wrong. I mean,
We've read the transcript, we've read the skeleton. It's clear what was being argued.
So, well, that really is the nub of our case on that core reasons challenge on which we have permission. There's the second point raised in the grant of permission about whether the Upper Tribunal were looking at the correct passage in the decision of the First Tier Tribunal in relation to the findings about my client's family. I adopt that. I don't think I need to say any more about it. But on that basis, we say that this appeal clearly falls to be allowed. And if we're right about that, we say the appropriate course is for this court to remit the matter back to the Upper Tribunal for it to be redetermined by a differently constituted panel.
So that again, remitted back to
a differently constituted panel of the Upper Tribunal for the Secretary of State's appeal to be reheard.
why can't we hear it?
You can, my lord. There's no bar to you hearing it, and that's obviously the point that Ms. Cohen will address if you suggest that's the more appropriate course. I'd suggest that the key point in my respectful submission is that my client has effectively been deprived of a fair hearing of his Upper Tribunal appeal because, as my lord, or Justice Holgate says, it simply was not determined. If this court were to determine it, he would effectively lose one of his tiers of appeal.
Yes, but if your appeal succeeds on a redetermination,
yes,
presumably it's got to go back to the FTT for facts to be found properly and a proper decision reached.
If our appeal succeeds.
Well, if on the redetermination of this point,
yes,
it's decided that there would have to be a further hearing in due course, and the FTT wouldn't there?
We say not. If the
because of the abundance of evidence.
Well, no, simply because it's an appeal on a point of law, and if there's no error of law in the First Tier Tribunal's decision
Oh, I see.
allowing my client's appeal,
Yeah, I see.
then that doesn't, there's no reason to interfere with that.
But so your argument that it should go back to the to UTIAC is dependent on the view that there is no error of law on this part of the case in what Judge Davey said. If on the other hand there was, then it would have to, this aspect of the case would have to be redetermined by the FTT.
That's correct, yes. And the question
That's
is...
really what I was trying to
Yes,
do.
I mean, if this court is with me that there is an error of law and the Secretary of State's appeal against Judge Davies' decision has to be redecided, then this court can either redecide it for itself or it can remit it to the Upper Tribunal. And our position is that in order to preserve a tier of appeal, the fair approach would be to remit it back to the Upper Tribunal, let the Upper Tribunal decide if there's an error of law in Judge Davies' decision, and if there is, it can remit to the First Tier Tribunal, and if there isn't, then...
Well, that's really the point I was putting to
Yeah,
you.
sorry.
That someone's got to take a view as to whether there was an error of law in Judge Davies' decision.
Exactly.
If there wasn't, then your client's not prejudiced. If there was, it has to go back to the FTT. Is
Yes.
it better for this court to get on with it rather than having this endless boomeranging between tribunals?
Yes, I mean, my submission resisting that is simply this point about protecting a tier of appeal, as it were. That if my client fails in this court, his only recourse is to the Supreme Court, which is only going to happen in the most exceptional circumstances. And there's already a high bar to appeal from.
I mean, it's not. Look, standing back and looking at it, there've been a lot of court hearings over this case.
Yes, yeah.
It's 8 years since your client arrived in this country. 9 years this year, isn't it? Some might think that this case has had more hearings than it needed.
Well, indeed, yes. Yeah.
So what do we really? I mean, of course, you're right in one sense. You need to preserve. Of course, there's merit in what you say, but wouldn't it be better use of resources for us to deal with it? It's not. It's probably not a very difficult point, is it?
I think that's a fair point. With respect, my lord. Yes.
Yeah.
We're
We're all here. I mean, 3 heads are better than heads, of course. Well, you've got at least 2 experts in the field. So, wouldn't it be better? Wouldn't it be better if we dealt with it really?
Can I just ask a further question on this general area, please, Mr. Denham? This is an appeal on a point of law. I mean, is it really the case that there's the specialist expertise of the Upper Tribunal would bring something different to a decision on this point of law?
Bring something different than this court.
Yes.
I don't think I can make that.
No. All right. Well, I just wanted
I mean,
to be clear whether you
but-
were running that point.
The lady has some experience sitting in the Upper Tribunal in this jurisdiction.
Yes.
Not that much.
And so does my lord. I don't, but
My lord, one additional point, just by way of-
to quote an old circuit judge I used to be in front of 40 years ago, shouldn't we grasp the nettle?
my lord, we're in the
That's
court's
an
hands.
old judge's comment, but shouldn't we do that?
I mean, my lord, I mean, you have my submissions. I entirely understand your position. I leave it in your hands.
All right. So,
My lord, one point of context, I mean, this doesn't really weigh either way, but it's not something that's immediately apparent on the papers that I think the court should probably be aware of, is that the remitted asylum element of the appeal
yes.
remains live for the First Tier Tribunal. That's
Yes.
yet to be determined.
Yes.
It's been, I understand from my instructing assistant, repeatedly adjourned pending the outcome of this.
Right. Well, isn't that another reason for not sending this your bit back to UTIAC? Why?
Well,
Isn't
my-
that another reason for grasping the nettle now? Then they could be heard together, if it's remitted.
If it's remitted, my lord, yes. No, I take the point. I take the point.
All right. Fine. Well, where do we go now?
My lord, I mean, I think at that juncture, it raises the question of if this court is going to redetermine it, just in terms of how today plays out,
Yeah.
at what stage should you hear from Ms. Cohen? I would respectfully suggest it should be after Mr. Brown's.
Mr. Brown, what do you think? Should we hear you next and then Ms. Cohen? You're going to have you'd have a chance to reply.
Yes, my lord, I'm entirely in the court's hands as to.
I know we're talking or talking over Miss Cohen's head. Is Miss Cohen content with that? Should we hear Mr. Brown next, Miss Cohen?
Of course, my lord.
Do you think that makes sense?
Yes.
Thank you.
My lord,
Happy with that?
Yeah, of course.
Anything else you want to say before Mr. Brown stands up?
my lord, no. I'll take everything I have to say about Mr.
You'll
Brown's
have
case
a
in one go.
Perfect. Right, Mr. Brown.
My lords, my lady, may I just start in light of the questions just posed to Mr. Denham with an authority of this court on its powers in statutory appeals. It's a decision that relates to the powers of this court
Where is it?
on appeals from the Employment Appeal Tribunal. My lords, my lady, it's at page 85 of the authorities bundle, Jaffrey and Lincoln College.
85.
Page 85. It is a decision which followed a discussion rather similar to that just had with Mr. Denham in a previous case called Upperlant and the University of Bournemouth, in which this court expressed a similar kind of frustration with what in that case was called the judicial ping-pong that can sometimes be involved between different courts and tribunals where there is or appears to be an error of law. And while in Bournemouth and University of Bournemouth and Buckland, this court had suggested that it had a power to determine for itself issues where the matter came before this court. In Jaffrey and Lincoln College, some constraints were placed on that by the Court of Appeal.
Okay.
The decision is expressed in relation to the powers of this court on appeals from the Employment Appeal Tribunal,
Right.
but the statutory schemes which relate to such appeals and appeals from the First Tier Tribunal via the Upper Tribunal, in my submission, are, to all intents and purposes, materially the same. The Court of Appeal said that where the only function of the Employment Appeal Tribunal, and by analogy with the Court of Appeal on Appeal, was to see that decisions of employment tribunals were lawfully made, and that if the Appeal Tribunal detected a legal error by an employment tribunal, it had to remit the matter, unless on the basis of the findings made by the employment tribunal, supplemented if at all only by undisputed or indisputable facts, it concluded either that the error could not have affected the result and was therefore immaterial, or that the result would have been different without the error, but that it was able to determine what the result would have been had the error not been made. And the Appeal Tribunal, therefore also the Court of Appeal, on further appeal, was not to make any factual assessment for itself or any judgment of its own as to the merits. And where more than one outcome was possible, the matter had to be remitted.
Yes, I've come across this in the employment context, actually. But, so you say it applies across the board, do you?
Sorry, but I'm not following this. Is this a response to the ground of appeal which the appellant is running, which is very simply, we did oppose the Secretary of State's argument and our legal opposition wasn't determined by the tribunal. Are you responding to that?
My Lord, yes.
Yeah.
Well, but I suppose
that doesn't involve any fact-finding.
My Lord, that I accept, but I suppose there are two errors of law wrapped up in the current proceedings, argued errors of law. Firstly, that of the First Tier Tribunal on the Secretary of State's appeal to the Upper Tribunal, and on this appeal, the error of law which is argued for by the appellants.
So you're dealing with you're dealing with the first one.
Well, I note that there are those two errors of law, and I suppose the prior question is which of the two decisions would this court focus on? Because
Well, the first decision, the immediate point, is the appeal from the UTAC, isn't it?
my Lord, of course. I mean, my
Lord's right. I mean, you've taken us to this case to deal with the second point, but that only arises if we're with Mr. Denham on his first point, doesn't it?
my Lord, yes.
So,
I
sorry, I'm being rather slow there.
No.
But if, for the sake of argument, the position is that the appellant did resist the Secretary of State's appeal on this part of the case,
Yes.
and the tribunal did not determine that, that's an error of law full stop, isn't it?
My lord, yes. And in those circumstances,
And it has to be grappled with, to borrow my lord's language.
yes, and the
So can we get on with it?
yes. Let me turn to that, but I just wanted to, as it were, to flag.
Okay, well, we may come back to that in a minute. What's your response to the principal ground?
Yes.
The principal view?
My response, I accept that the Upper Tribunal's reasoning is sparse, but I don't accept.
That's not a very bold concept, but sorry, Mr. Brown.
But it's where is the reasoning? It's non-existent, isn't it?
Well,
Well, how do you put it?
I put it that these were reasons appeals by each of the parties. The Upper Tribunal is concerned with the reasoning of the First Tier Tribunal in two respects. The context to the decision that the Upper Tribunal is ultimately reaching is a concession made by the Secretary of State before the Upper Tribunal.
Yeah.
That the First Tier Tribunal's reasoning
On the
protection grounds is deficient.
Yeah.
So this is a case where the Upper Tribunal is starting from the point that the parties agree that at least some aspect of the First Tier Tribunal's reasoning is deficient.
Yes. They didn't agree that all aspects.
Yes.
Although they obviously overlap in many ways, they are discrete.
The appellant's case was the reasoning. There's enough there. I should have succeeded.
Well, in my submission, I mean, the way that the Upper Tribunal characterised the appellant's submissions, page 76 of the core bundle, paragraph 26. My submission is correct. I can seek to make good that point.
Paragraph 26.
Page 76 of the core bundle, paragraph 27. Ms. Cohen submitted that there was overwhelming evidence for both a lack of family support and a risk of intense suffering on return. My lords, my lady, page 81 of the core bundle.
Well, that's a very cryptic and concise summary of Ms. Cohen's submissions, but we've seen her skeleton argument, and there was a little bit more than that in her skeleton argument, wasn't there?
I accept that the skeleton argument is a detailed one.
Yes.
Page 81 of the core bundle.
This is
This is part of
is Miss Cohen's skeleton.
This is Ms. Cohen's skeleton.
So this is right.
And this is the second page of the submissions that Ms. Cohen made in writing.
Yeah.
Paragraph 15 on that page. Yeah. The respondent's appeal is characterised by her as a disagreement with aspects of the evidence. She says the respondent's grounds essentially amount to a disagreement that, then she refers to two aspects of the evidence. Ms. Cohen then sets out the findings, or some of them, made by the First Tier Tribunal judge at paragraph 16.
Yeah.
Paragraph 17 is not part of the reasoning of the First Tier Tribunal judge. It is parts of the documentary evidence that Ms. Cohen has set out from the evidence that was before the First Tier Tribunal judge. And paragraph 18.2, which is paragraph 18 also, is Ms. Cohen setting out evidence that was before the First Tier Tribunal judge, not Ms. Cohen identifying in the reasons of the First Tier Tribunal judge reasons to support the Secretary of State's two grounds of appeal. And those grounds of appeal were not, as Ms. Cohen characterised them at paragraph 15, disagreements by the Secretary of State with the evidence. The Upper Tribunal has set out what the grounds of appeal were in its decision, core bundle, page 75, paragraph 19. They are two failures to explain by the First Tier Tribunal. And so the Secretary of State, having brought a reasoned appeal, not a perversity appeal, and having put in issue the equality of the First Tier Tribunal's explanation of its decision, Ms. Cohen firstly characterises that as a disagreement about evidence, and then identifies evidence that was before the tribunal.
Well, hold on a minute. What about paragraph 14? She clearly says, on a closer examination of determination as permitted at the error of law stage, the benefit of submissions, clear the determination contains adequate reasons for its finding that the appellant's removal would give rise to breach of 3-8. So she was squarely contending that the reasons were good enough. And the rest of the skeleton explains why she says that the reasons were good enough.
What Ms Cohen does, having made that contention, is then in the following paragraph characterise the grounds of appeal as in truth a quarrel with the evidence. Sets out of paragraph 16 findings made by the judge, but it isn't able to justify the reasoning of the First Tier Tribunal judge.
Well, that's a matter of opinion, but her argument was the reasons are good enough. If you look at all the background. I mean, she's clearly saying that in paragraph 14, isn't she?
I accept that that's her contention in paragraph 14.
But your case then, so far, have I got this right, is that paragraph 27 of the Upper Tribunal's reasoning, although sparse, to use your word, is a sufficient summary of Miss Cohen's case.
Well, yes, I submit that that is a sufficient summary of Ms Cohen's case.
Right. So my question... Oh, sorry, I interrupted you.
No.
So my question then is, where do we find the Upper Tribunal Upper Tribunal, giving its reasons for rejecting her case?
Well, my lord, what I submit is that paragraph 27 doesn't stand in isolation.
Right.
That the Upper Tribunal has set out what were in fact the grounds of appeal. Core bundle, page 75, paragraph 19.
Yeah.
Ms Cohen's submissions are characterised as there being overwhelming evidence for both the lack of family support and a risk of intense suffering on return. As to the latter point, in oral submissions, Ms Cohen accepts before the Upper Tribunal that the judge nowhere refers to the language of intense suffering on return in the First Tier Tribunal decision. And so and similarly in her skeleton, in respect of the, I stress, these are in no way criticisms of my learned friend. My focus is on the way that the Upper Tribunal dealt with the submissions that were made. Paragraph 19 of her skeleton on page 84, Ms Cohen also accepts that there was a failure by the judge to refer to section 117B of the 2002 Act, which is germane to Article 8 appeals. So there are many acceptances by Ms Cohen that there are aspects of what one might expect in the First Tier Tribunal judgment which are lacking, including in respect of the Article 3 human rights claim, the key issue of fact for the First Tier Tribunal, namely whether the person in question, if returned, would face intense suffering. So she accepts that those are absent.
But just to go back to paragraph 19, she does accept that there's no express reference to 117B, but she goes on to say, in effect, it doesn't matter because it's clear if you look at the determination that that's the approach he's adopted. I mean, that's a submission. It might be right, it might be wrong, but it's a submission that's being made.
My lady, I accept
so
that.
She's not just throwing in the towel about section 117B in that skeleton.
No, I accept that there is. It's not submitted by her that. In my submission, the Upper Tribunal were fully apprised of the fact that the appellant was not accepting, as the Secretary of State had, that there was an error of law in the First Tier Tribunal's decision. The Upper Tribunal very briefly summarise seek to encapsulate the submissions that were made, but in my submission reached the decision that the First Tier Tribunal's judgment was deficiently reasoned.
Why?
Because the Upper Tribunal preferred the submissions of the Secretary of State.
Where did they say that?
That in my submission is the effect of paragraph 28 of their decision on page 77.
Which words say that?
Given those concerns and the mirror criticism of the First Tier judge's reasons by
Well,
both.
mirror
Where do they
criticism-
refer to the fact that they're, I beg your pardon,
No, you go
It's
ahead.
not helpful, Mr. Brown. I'm sorry. Forgive us for all questioning you.
Not at all.
Perhaps my lord, as he was first out of the
Yes.
out of the trap, would like to go.
Well, it's just, I mean, where do we find the words where they say we don't accept the submissions made on behalf of the appellant? If anything, it goes the other way because of the reference to mirror criticism, combined with the judge's decision on the application for permission to appeal.
The mirror criticisms are those of each of the parties, saying that the First Tier Tribunal's judges' reasons were
So we've got the criticisms,
But
but
we haven't got mirror concessions. We've got concessions by the Secretary of
or
State.
the
but-
response by one party
Yeah.
to the criticism.
Exactly.
Isn't the word mirror the difficulty for you? Because mirror it sort of implies, to me at least, that the judge thought that you both were saying more or less the same thing. This judgment was defective for similar reasons, and therefore it couldn't stand. But shouldn't the Upper Tribunal have engaged with each point separately, rather than
Rolling it all up into mirror criticisms.
I readily accept that the rolling up of it is less comprehensive reasoning than there might be.
Well, it's very simple. One set of criticisms, that made by the appellant in relation to the protection claim, was accepted by the Secretary of State. On the other hand, the criticisms made by the appellant in relation to the the other set of criticisms in relation to the human rights claim weren't accepted by it. So they weren't actually mirror if you look at their cases as a whole. And it's compounded by the PTA decision at page 66, paragraph 9. Ms. Cohen raised no objection to the First Tier Tribunal's decision being set aside and remain. She did.
The criticisms of my submission are mirror criticisms. The response of the counterparty to those criticisms is not the mirror. And the Upper Tribunal deal with that because instead of there being a mirror to paragraph 25, which shows acceptance or indeed reflects the permission to appeal decision, the Upper Tribunal note Ms. Cohen's submissions. They do it briefly. They explain the brevity for it in the permission to appeal decision, which is they say that the situation didn't merit a lengthy decision because in essence of the mirror criticisms.
Well, it didn't merit any detailed reasoning in relation to the protection because the Secretary of State rolled over on that.
Yes.
But it doesn't follow that there is no reasoning needed in relation to the appellant's appeal because the appellant didn't roll over and clearly didn't roll over, and yet the Upper Tribunal appears to have thought that the appellant had rolled over. See the PTA decision.
Well, what in my submission the PTA decision reflects is two matters that were before the Upper Tribunal. Firstly, in the appellant's skeleton argument, core bundle, page 87, paragraph 29. Ms. Cohen said, if the Upper Tribunal concludes that the determination discloses a material error of law, the Tribunal is invited to remit the appeal to be heard de novo. That is amplified in the oral submissions that were made at page 200 of the supplemental bundle. I should observe if this transcript has been read or in whole or in part by the court, it doesn't appear to be a perfect transcript. again, I understand it was a text-to-speech transcript, so
Yes.
it automatically generated.
Well,
rather than,
are you satisfied that it contains an accurate, sufficiently accurate summary of what was said?
for my purposes, yes, but I raise that because of the infelicities in it.
Can I just clarify one, just on a factual point? It was a transcription made by a person who was transcribing. It wasn't
I
an
see.
automatic
Oh, okay.
computer
In
generated
that
transcription.
case, I've been informed wrongly. I'd understood it was automatic. I raise it only in case a factual point is taken, but in the
But
middle
is
of
it an agreed transcript? If that matters. Agreed between the parties, I mean. Well, that's what we have with transcripts.
yes.
We get issues with transcripts all the time, inaudibles, etc. Is this agreed?
I agree with it, and since it's the
Right.
since it's the appellant who relies on it, I assume that they put
Okay.
it forward as accurate.
Right, so where do we go? Page 200.
So to page 200, in the top of the page is Ms. Cohen's submissions, and my lords, my lady will see that in the middle of the page. It says, therefore, I invite the tribunal to find that there's then a gap, so something is missing. And Ms. Cohen then says, should I make submissions on that? It appears that might be about anonymity.
Yes.
And then Upper Tribunal Judge Gleeson says, so you want us to dismiss the Secretary of State's appeal and allow yours? Ms. Cohen says, yes, in terms of remittal.
No, yes, full stop. Yes.
Yes.
In terms of remittal. So what she's saying is, yes, that's my submission. And then let's move on to another topic, remittal. And then Gleeson, Upper Tribunal Judge Gleeson says, why be remitting it? Blah, blah, blah. And she explains why it should be remitted.
Yes. And the reasons for that are need updated medical evidence and need updated country expert evidence. Matters which in my submission apply equally to both aspects of the statutory appeal that had been before the First Tier Tribunal, and are in the context of what Ms. Cohen had said at paragraph 29 of her skeleton argument on page 87. So that in my submission was the appellant's case on the issue of remittal as before the Upper Tribunal. But I submit that the Upper Tribunal, from its ultimate written reasons, clearly did not proceed on the basis that the appellant had, to speak colloquially, thrown in the towel on the Secretary of State's human rights.
And the reasons why the Upper Tribunal rejected Ms. Cohen's submissions, you say, do you, that paragraph 28 is sufficient?
I say that paragraph 28, taken with paragraph 19, which set out the actual grounds for appeal, and the reference at paragraph 24 to the oral submissions, which the Upper Tribunal says are a matter of record and need not be set out in full here. So those are essentially being incorporated by reference into the Upper Tribunal's decision. The following paragraphs 25 to 27, and then the conclusion that is reached at paragraph 28, amount to the Upper Tribunal saying we prefer the submissions of the Secretary of State to those of the appellant, and we have incorporated by reference those submissions into our decision.
Thank you.
Those
That's
are
your point
on reasons.
Yes. Well, now, do you want to, what do you want to say next? Do you want to go on now?
I'm entirely in the hands of the court in light of where things have reached.
Maybe you sort of deal with the conflict between paragraphs 12 and 16. Look at Elisabeth's part.
Yeah, 12 and 16. I'll just see what that was. Paragraph 12 and 16.
We might have to hear from them first.
Yes, I think
Yeah.
we will. Yeah, because it's really that important.
Right. Thank you. Well, I think we now go back to the appellant.
I think we're dealing with
Whether we deal with it or not. So,
I think we do deal with it. We're now going to
yes. So at the moment, well, does Mr. Brown, do you want to say, we're minded to hear submissions now on the point. Do you want to say anything else? Do you want to deal with Jaffrey?
I mean, I think I've probably said as much as I was going to, just to bring to the court's attention what this court has previously said.
But do you say we're in any way constrained from dealing with it ourselves as a result of Jaffrey?
Well, my lord, I suppose it depends on the question of what this court would be doing and in respect of which decision. I think that the parties to this appeal agree that the preliminary focus of this appeal is the correctness or otherwise of the Upper Tribunal's decision. If this court concludes that that decision was itself in error of law, the starting point would be the remittal of the matter to the Upper Tribunal, for the Upper Tribunal to consider the Secretary of State's appeal to it and reach a proper decision.
We've expressed concern about
Yes.
that when Mr. Denham was addressing us.
Yes.
Can one really separate the Upper Tribunal from the First Tier Tribunal? Because the real question is, did the First Tier Tribunal err in law? And in relation to either limb of the appeal to the First Tier Tribunal? And if it did or it didn't, that's really what's critical, isn't it? It doesn't really matter what the UT held, except that if the UT has got wrong whether the First Tier Tribunal erred in law, then that's a problem. And it may be that the Upper Tribunal's argued errors of, I don't know, no, I'm not being very coherent.
I mean, what you say to the point is it's a waste of, it's a misuse of resources to send the matter back to the UTI. When why can't we deal with the point here? What do you say to that? You say Jaffrey says we shouldn't do that, or we should be careful before doing it. What's your point?
My point about Jaffrey is that it constrains the powers of this court.
Well, I don't understand this. Somebody has got, say for the sake of argument, that the opposition to your client's appeal wasn't determined by the Upper Tribunal. Say for the sake of argument, that's the position this court reaches. It then needs to be determined. And the only question my lord is asking you about is whether we deal with it or it goes back to UTAC to deal with it. If it goes back to UTAC, insofar as there is a Lincoln College point, it would arise there. It arises either there or here. But what's being said is that there is a point of law to be determined if it hasn't yet been determined. Now, is there any reason why this court shouldn't deal with the point of law?
No, I accept that this court can deal with the point of law.
Yeah.
Thank you.
So I think then...
Back to Miss Cohen.
Exactly.
We'll now have Miss Cohen. Is it all right, Miss Cohen? Are you ready to go?
Of course.
All right. So now we're going. So this is you now having a chance to make the point that substantive points on this issue. Now, what do you want to say?
I'm grateful. So the respondent's grounds for the application of Commission on Human Rights grounds on their side, they raised 3 grounds of appeal.
Yes.
I don't ask your Lord and Ladyship to turn them up now, but just by way of summary. The respondent submitted that inadequate reasons were provided for finding very significant obstacles for the 276 AD 16 paragraph of the immigration rules test in respect of the appellant's reintegration in Morocco, by reference to whether he could rely on his family on return.
I think, could you go a little bit more slowly? Just say that again, please. Is this written down clearly, rather than save some
Perhaps I
time?
might refer your Lordship to the grounds.
Yes, that would be better, I think.
At page 125, the core bundle.
Thank you. Right. So,
Paragraph 3. What we glean from the application. Paragraph 3 is the respondent's submission that there were inadequate reasons were finding that, that there are very significant obstacles to reintegration.
Yeah. Yes.
At paragraph 5 to 6.
Sorry, I missed that paragraph.
5 to 6.
Yes.
The respondent referred to the requirement of intense suffering
Yeah.
in one of the limbs of A.M. Zimbabwe, and submitted that the evidence that was before the first tier did not in fact meet that threshold.
Yes.
And then at paragraph 11, the respondent averred a failure on the part of the first tier to direct itself by reference to those public interest considerations that have been discussed already.
Little or no consideration to the public interest removal.
I don't think it can be said that there was no consideration. I have to accept that there's no explicit reference to 117B, but I will take your Lord and Ladyship to the paragraph where the First Tier Tribunal judge clearly dealt with the public interest question.
Right.
And then just before I go there, in the determination at paragraph 16, page 133 of the core bundle,
Yes.
you see under the fifth point, so in about the towards the bottom.
I'm so sorry, I beg your pardon. Could you just give me the page?
The appellant's family. Sorry.
I beg your pardon. Could you give me the page reference again?
Sorry, the page reference is 133 of the core.
I beg your pardon. Thank you.
So we're now in Judge Davies'
Oh yeah, sorry.
reasons decision.
Yeah, part of them.
Yep.
And I propose to take your Lord and Ladyship to the determination briefly before I take you to the evidence, and then back to the determination if I may.
Thank you.
So towards the bottom of paragraph 16,
Yes.
we see the judge expressly finds that the appellant's family may provide some supportive structure, but the appellant did not communicate his difficulties with them. And we say that that was a finding that was rationally open to the judge based on the evidence before.
Is this exactly a finding? I mean, what the FTT says is, I take into account Dr. Day's conclusions, and then he sets out 5 conclusions. So he says he's taking them into account, but is he actually making a finding?
I mean, taking that together, that paragraph together with what I think is the second paragraph 14. And say that that must amount to a
Can I ask a question?
Of course.
You're going to the support structure. This is the insuperable obstacles, or serious obstacles, I beg your pardon.
Very significant obstacle.
Which was the first of the 2 issues raised by the Secretary of State.
Yes, so it's the Article 8,
Which-
276.
And that comes in under Article 8.
It does in terms of the immigration rules.
Yes. But also in terms of the case law, one should look at Article 3 before Article 8,
If it is raised,
which it was here.
it was.
Yes. I'm just trying to simplify things. And in fact, it's the Secretary of State's second ground of appeal, which goes to Article 3.
Yes.
I think it might help us if we were to see how that aspect was dealt with first. It's dealt with in paragraph 16. And can I just ask 1 or 2 simple questions? I think the Secretary of State is saying that the decision of the Court of Appeal in GS is still good law, looking at the relationship between Articles 3 and 8. I don't see you disagreeing with that anywhere.
So I think perhaps I should take your Lord and Ladyship to GS India.
Well, so to the which one?
To GS India.
Yes,
Well-
but could you just answer the question? Do you say it's no longer good law?
It's not so much that it's no longer good law. I say so. The respondent conflates the substantive provisions under Article 3 with the substantive provisions under Article 8.
Yeah.
Yes.
And I say that's incorrect.
Understood.
They are two distinct.
Okay, well, a simpler question then. AM, the decision in AM,
AM Zimbabwe.
Zimbabwe, thank you very much. I mean, the critical question there is whether an individual would be exposed to a serious, rapid and irreversible decline in the state of health resulting in intense suffering. As I think we understand it, this is referring to the risk of suicide.
Yes, so there are two limbs. There are, and this is actually quite clearly set out in the Upper Tribunal decision of AM Zimbabwe, which follows on, which is that there's a first requirement of the sort of intense suffering, which is the circumstances facing the appellant on return. But then there's also the requirement or alternative outcome, which is the shortened life expectancy.
But in the Article 3 part of the case,
Yes.
that's the critical issue here, isn't it?
Yes. But
And the risk of suicide.
yes, so both of those limbs.
Yeah.
So the intense suffering and the shortened life expectancy.
Absolutely. And that's dealt with, I think you're saying, in paragraph 16 of Judge Davies' decision. Is that correct? Page 133 of the bundle.
I'm grateful.
Point 3 and 4.
Exactly.
Yes. Well, taking.
It's specifically at 4, but also, I think, in the context of
Yes.
3.
Yes. But that you would rely upon as part of the overwhelming evidence.
Exactly, my lord.
Yes.
I
You set it
wonder-
out very clearly in your skeleton. But I think a question we have is, would you be kind enough to go back to paragraph 12 on page 132,
Yes, my lord.
where the judge deals with suicide risk again? Relied upon but more difficult to assess was that the appellant on return would face an increased risk of suicidal ideation or attempts at suicide. I did not find the evidence sufficiently coherent to reach any firm conclusion on that matter, but sufficient to say his mental health would be an indicator of greater vulnerability if subject to pressing examination by the security forces on a return to Morocco.
Yes, my lord.
Well, that contradicts his reliance upon this evidence at 16, doesn't it? One stage he's saying he can't make a finding on suicide risk, but nonetheless appears to be doing so, if it is, as my lady says, a finding, in paragraph 16.
But that is one of the other limbs, the alternative limb, under Article 3 in the test,
Alternative to what?
to the intense suffering. So if there is a finding on the intense suffering, that's sufficient. Perhaps I might take your lordship to the AM Zimbabwe's Upper
Yes,
Tribunal.
but before we do that,
Yes.
if we're just looking, we look at intense suffering, but if we're just looking at suicide risk, doesn't there appear to be a straight conflict between 12 and 16? And if there is, it would be an error of law.
Yes. I mean, obviously at 16, as my ladyship said, you know, the judge is taking into account Dr. Day's conclusion.
Rather than making a finding.
I mean, at 16, he's doing a different thing from what he's doing at 12.
Very much so.
That's your point, is it? At 12, he's focusing on suicide specifically. Is that right?
Yes.
As a
He's also
limb of Article 3.
But he's also dealing with the questioning at the airport. And
Okay.
Oh, yes, we understand that, but the trouble is, if you look at 17, he then says, thus, it seemed to me, looking at everything in the round, he's quite keen on that, because at what is numbered as 14, but is actually 19, he says, looking at all the evidence in the round. So he seems to be taking on board what he's taken the trouble to set out in 16 in his conclusions in the last two paragraphs. Otherwise, what's 16 doing there?
16 is obviously the clear expression there is in relation to very significant obstacles on return in terms of that assessment under the immigration rules.
But I'm sorry, but forgive me, at 134, at the end of 17, he says, therefore, whilst this appeal is being determined in the context, as you point out, the immigration rules, I consider the claim in terms of whether these difficulties constitute or are likely to constitute a breach of Article 3, and also whether or not he engages with Article 8. So he sweeps it all together.
Yeah,
I mean, my simple understanding of this area of the law is that you look at these articles one by one. You look at Article 3, you reach your findings on that, because there are certain tests which have to be applied. You look at Article 8, and you look at, in that context, also the immigration rules.
yes, well, I
You
think
don't sweep it all together.
well, I think what I would say is that this reflects the nature of the evidence in these kind of cases, which very much goes to each aspect of Article 3, Article 8 under the rules, and Article 8 in terms of the radical assessment.
Because the immigration rule you helpfully refer to is only dealing with Article 8, isn't it? The obstacles test.
Yes.
But in any event, the question we're really asking is there not a conflict as regards dealing with Article 3 between what is said in paragraph 12 on suicide risk and then what is said in paragraph 16 on suicide risk?
I think in terms of, I can see that at first blush it may appear to be an inconsistency, but I think what I say is that the judge quite clearly finds that the intense suffering category to be met. And I wonder whether, perhaps before I take you through the determination more as a whole, I can take your Lord and Ladyships through the evidence that was before the judge that may add some clarity to the way in which these issues have been dealt with.
The evidence is one thing. The question is whether the judge understood what law he was applying to the evidence. And at the moment, if you look at paragraph 14 bis, which should be paragraph 18, what he says about Article 3, his express reasoning about Article 3 is real risk of Article 3 or treatment either arising through societal discrimination or through the state in its treatment of him. So there's no reference to either limb of the right test, is there? There's no reference to intense suffering or to shortened life expectancy.
No, my Ladyship.
Now, I'm very conscious we've interrupted you quite a lot. You were going to take us to AM Zimbabwe, I think.
I was. I wonder if perhaps before I go there, I should take your Lord and Ladyships through the evidence that was before.
Yes, well, if you want to do that, then please do.
Will our understanding of that evidence be affected by some point of principle in AM Zimbabwe that you want to talk about?
I'm sorry, my Lord.
Well, I'm just concerned in case what you want to say about AM Zimbabwe might affect what we glean from the evidence.
So perhaps I should take your Lord and Ladyships.
I think it would help me, and you'll remember, Ms. Kern, this is not my specialist area. It would help me in if we looked at the case first, Zimbabwe first,
I'm grateful.
so that then I would have some firm, lanes to keep me on track.
I'm grateful.
Okay, so we're authorities bundle, and it's tab third, tab 14.
Start with the Upper Tribunal decision, which helpfully sets out the task, and that starts at page 223 of the authorities bundle.
Okay.
We see at head note 1 the.
I'm really sorry, I got
I'm
wrong.
sorry.
Can you give me the page reference? Is it
223. We're at the Upper Tribunal. Am I in the right place?
Yes, my lord.
Can I just check, is everything working all right so far as you're concerned, stenographer? And so far as you're concerned, in terms of
my
the,
lord.
it's working all right.
I'm grateful.
Do let me know if it's not.
I will. I'm grateful.
Thank you. All right. So page 223.
Is it 224?
224 is the
That's the head note.
head note. Yes.
And we see the application of the AM Zimbabwe test. So the first limb is, has the person discharged the burden of establishing that he or she is a seriously ill person? Secondly, if that aspect of the test is met, has the person adduced evidence that is capable of demonstrating that substantial grounds have been shown for believing that as that seriously ill person, he or she would face a real risk on account of the absence of appropriate treatment or the lack of access to such treatment, which is the aspect that we rely on, of being exposed either to a serious, rapid, and irreversible decline resulting in intense suffering or a significant reduction in life expectancy.
So should I underline
Or the lack of access.
or the lack of access to such treatment in 1, and a significant reduction in life expectancy in 2?
Or perhaps just the or between the two limbs.
And the or. Thank you.
So it's either a serious, rapid or irreversible decline or a significant reduction in life expectancy caused by the absence of appropriate treatment or lack of access to it.
I thought it was lack of access in 1. Have I got that? Am I in the wrong place?
I think you were making both points, weren't you? That there are relatively, there are fewer psychiatric facilities in Morocco compared to other countries, and also a lack of access to whatever is available in Morocco.
Yes.
Right. Thank you.
So that's the contact to AM Zimbabwe. Should I deal with the distinct nature of Article 3 and Article 8?
If you could briefly, thank you.
So probably right to start with GS India.
Yes.
Start page.
So on tab 9, 103.
Paragraph 39 of the judgment.
This is in Lord Justice Law's judgment, is it? Yes, 39. Thank you.
There is a small delay on the transcript.
I know.
You've noticed.
Thank you. I'm sorry if I forget that for a moment. Paragraph 39
Paragraph
in Lord Justice Law's judgment.
Yes. So we see there a summary of Article 3 as opposed to Article 8.
Yeah.
So we know that as regards Article 3, the ill treatment must attain a minimum level of severity. but the formula is at too high a level of generality to provide or even suggest a paradigm. The language of the article shows that the paradigm case is an act which constitutes torture or inhuman or degrading treatment or punishment. And then the paradigm of Article 8 is much more diffuse.
Yeah.
Unlike Article 3, no single paradigm may be obtained from its language. The overall value which the article protects may be said to be the quality of life. And there's nothing surprising about that, because of course if one looks at the Rajgar assessment, that's very much focused on the life that the appellant has.
Yes.
What slightly complicates the picture perhaps is of course paragraph 276 AD 16 of the immigration rules looks primarily or materially at whether there are very significant obstacles in the country of the time.
Yeah.
That's the slight.
Okay.
But what I say is that the authorities do not support the proposition that the respondent puts forward, that there is necessarily a need to take into account the task that is established under Article 3 in carrying out what is, I say, the very separate assessment under Article 8.
Right. Thank you. Anything else you want to show us in GS?
I mean, could I ask about paragraphs 85 to 87, headed the Article 8 claims, at page 131 to 132?
I'm grateful.
Do they still remain good law?
So I think it's important to appreciate. So what I will say about GS India is that, as I say, it doesn't support the proposition that the respondent puts forward. But the law has developed. I think that's probably more.
That's why I asked the question whether it's still good law. I mean, this is the point which has clearly been raised by the Secretary of State, and I hadn't seen it challenged by the appellant.
As we say, you know, the two are distinct. In terms of,
Well, do you want to say anything about those paragraphs, 85 to 87, or anything else in GS?
So what we say is that nothing in those paragraphs suggests that one cannot succeed under one right if the claim has failed under another. And the reference to Article 8 not prospering, which is paragraph 86, when read in context with paragraphs 85 and 87, simply illustrates the different factors that are relevant to an Article 8 claim.
Can I ask specifically, do you accept that the first sentence of 86 is still good law?
No, ma'am.
So where do we go to see it challenged, overturned?
I think perhaps before I mean, I don't think I can refer to an authority in the bundle that explicitly deals with that. But what I would say is that firstly, in GS India, none of the appellants had raised Article 8 claims at all, and so it's not part of the ratio.
You say it's obiter.
Well, I think I say that it wasn't part of the ratio of decision making by the court in GS.
Right.
Which in any event recognised the very distinct nature of the article.
So on what basis do you say it's not good law, if that is your case?
Well, that first sentence of paragraph 86, I think would require, at the very least, recognition that Article 8 wasn't being raised in GS.
But whether or not the statement in the first sentence of 86 is obiter in GS India, Lord Justice Laws cites a passage from an earlier case, and then Zimbabwe, which is to similar effect.
I don't recall that going as part of the decision of the Supreme Court in Laing and Berkeley, which, as I recall, proceeded only on the Article 3 test.
Okay.
But in any event,
I'm sorry.
but in any event, it might be helpful to go back to see what Judge Smith said in this protracted litigation, tab 22 of the core bundle.
This is Judge Smith in this case.
In this case,
That I saw was part of the Constitution in AM Zimbabwe.
Because-
We're going to this case.
because he considered this very point in telling the FTT what it had to do. And this is what presumably Judge Davey was supposed to do. But if you go to page 143, paragraph 131, he doesn't cite GS, he refers to another case, PF Nigeria, in similar terms, but he looks at the relationship between Articles 3 and 8. And there was no appeal against that decision. He says Article 8 claims are not lesser form of Article 3 claims. An assessment of what amounts to very significant obstacles based on a health claim should take place in the context of the health claim having also been assessed within Article 3. So that's how he saw the law applying to this case. Was he wrong?
Well, yes, because as I say, that the evidence will very much overlap in terms of looking at what the conditions are, what the appellant's circumstances will be in the country of return. That's the complicating factor, I think, that paragraph 276 AD 16 adds to the mix in article.
But he goes on to criticise the FTT first time round because they didn't deal with Article 3 separately before going on to deal with Article 8. Again, was he wrong?
I think much of it will come down to the evidence that applies in a case such as that.
Right. Well, is there anything else on the case law that you want to show us? Or do you now want to take us to the points of the evidence on which you rely?
I'm in your hands.
What do you want to do?
I'm great.
I think I've now seen the tram lines, as I put it, in the case law. And if you're content that we have that, I have it, and everybody has it, then let's go to the evidence.
I'm great. So perhaps you might start with the appellant's witness statement, which was before the judge, at page 23 of the supplementary bundle.
Just give me that page number again, could you?
23.
23, thank you.
Right. Would you like us to read some specific paragraphs of this statement, and if so, which one?
I'm great. Starting with paragraph 8. You see,
Yep. Yes?
we see in paragraph 8 that the appellant states that talking about my mental state is very difficult.
Yes?
Makes me feel rash, so I do not like talking about it. Normally, I talk about my mental state as little as possible.
Yeah.
And then at paragraph 12, the
Yes.
appellant explains that the problem started in 2012 and was about 12 years old.
Yes.
Materially, I think my family perceived I was sometimes isolating myself. They did not do anything about it. I suppose they thought that there was nothing they could do to help.
Yeah.
Down the page, paragraph 17, my normal reaction when I feel low is to keep myself to myself. I withdraw, isolate myself in my room. During these periods, it feels as I am putting myself in solitary confinement in prison. There is nothing in my mind that allows me to, or pushes me to get out of it. Over the page, paragraph 18, periods can last for weeks. And during those times, I avoid talking to anyone, including his family and his school records. And then at paragraph 22, the appellant grapples with why he has not, and likely would not, tell his family about his mental health. So, I have not told them about my mental health. I've not told them anything about it. I do not tell them about how I'm feeling. He says, I do not want to worry my mother, but also I do not think my mother would understand. There is not the same consideration or understanding of mental health issues in Morocco. It's just a question of you feel good or you feel bad. Not specific. There's no help like there is here. Mental health issues are taken seriously here, not like that in Morocco. He states, I think my mother would understand if I told her I did not feel good. Well, I do not think she could understand more than that. I do not think she would know how to help me. And again, paragraph 23, during these periods of isolation, sometimes he sleeps, sometimes he doesn't. He's not interested in food. And then at page 32.
Page 32.
32.
Thank you.
Paragraph 59. He expresses his fears for his mental health if he is required to return. I do not think I could keep myself safe without the support that I get here for my mental health in daily life. I do not think my family would know how to fix. And so we see that the appellant has not told his mother about his mental illness for 2 reasons. Firstly, because of his feeling about the stigma that is associated with mental illness. And secondly, because he believes that in fact there is nothing that his family could do to help him based on his past experience. We then turn to the evidence of the appellant's support worker, Ms. Lunny, which starts at page 37 of the supplementary content.
So, can we have the reference again?
And so the reference to page 37.
Thank you.
Support worker. Yes?
At paragraph 16.
16.
16 at the bottom of the page. At the bottom of page 36. We see that, in her view, the appellant often struggles to engage and requires a lot of additional outreach effort. And this is particularly the case over the page of paragraph 17 when he is in a mental health crisis. She corroborates what he says about him shutting himself in the house and isolating, cutting communication. She reports that he told her that he just feels unable to have any communication at all. He becomes very distressed, anxious and paranoid about how people will perceive him if they do come across him, or how they will think of him. And what she goes on to say, in her opinion, as a person who has worked with young people like the appellant, at paragraph 19, is that the appellant's inability to seek help is quite complex, because it's not only due to his symptoms, such as feeling down, not being able to actually communicate that, but also because of the cultural stigma of mental health problems. Refers in more detail to that paragraph 20. And then at paragraph 22, Ms. Nonny corroborates what the appellant says about not telling his family about his mental health problems.
Shameful is the word he uses. She uses.
Exactly.
Quoting him. Yes?
Yes, at paragraph 22. So, Miss Nolly states she expressly asked the appellant, why have you not told your family? And she corroborates his case as to why he has not done. If we then turn to the psychiatric report of Dr. Day,
Right.
that's page 69
Thank you.
of the supplementary bundle.
Page 69.
69. So it's subparagraph B.
In answer to question, which question? Q.
I'm sorry, which instruction? So, page 22, question 9. The
I'm s-
appellant's likely psychiatric reaction to the news.
Yes,
And
thank you.
Paragraph B, what Dr. Day states is that given his psychosis, he would imagine that a forced removal would be a reenactment of mental health phenomena that he undergoes. He would feel controlled, made to do something against his will, which would trigger feelings of powerlessness and a loss of control. This can be expected, in her express opinion, to lead to a worsening of his internal world with a feeling that those beings have taken control of him. And she referred to the risk of suicide. At question 10, as to the relevance of his mental health to his ability to actually integrate or access treatment and support, question 10A, she states it would make it very, his psychotic illness would make it very difficult for him to do anything practical, say for example seek employment or seeking help for himself. He is unlikely to seek help for his mental health difficulties. He will continue to self-medicate using drugs that are likely to in fact worsen his mental state.
Are you saying that's something separate from the suicide risk issue? Something which goes directly to Article 8?
It also goes to Article 8.
Okay.
In terms, and what she states, what Dr. Day states at paragraph D, is that in terms of caring and looking after himself, he currently requires the help of 3 support or key workers to help him do this. Given his mental state is likely to deteriorate, it is very unlikely that he would be able to do this himself. We also see, just on the point about suicide, at question 12A, that psychosis and schizophrenia are associated with an increased risk of completed suicide. Over the page, as the psychosis deteriorates, his risk of suicide will greatly increase. And what Dr. Day also states is that, quite apart from his own individual circumstances, he also carries many of the high-risk traits for completed suicide. He's a young male, diagnosis of first episode psychosis, current substance misuse, and a history of mood problems. And she concludes at question 13A, there would be a significant increase of the suicide risk if the appellant is returned. And so just thinking about the requirement of intense suffering to that first limb, I submit that it's instructive to look at what the symptoms of the appellant's psychosis actually entail. So at page 61 of the supplementary bundle. Below question 1, you see the diagnosis of first episode psychosis and the following features: paranoid grandiose delusions, thought insertion, auditory hallucinations, disorganization of speech and thought, and then social withdrawal, mood symptoms, and functional impairment.
Yes.
And then finally at page 67, you see that the appellant's prognosis is poor in the long term because of the risk factors that apply. And what we say is that taking that evidence together with the appellant's witness statement, which is corroborated by his support worker, that clearly meets the requirement of intense
Requirements for,
suffering.
yes.
Don't you have to go a bit further? Don't you have to submit that no decision maker, when faced with this evidence, could conclude other than that the tests in AM Zimbabwe are met? Do you submit that?
This is the respondent's submission is that there was no basis for the judge to indicate that there was intense suffering, that requirement was met.
I see. So your submission is to counter the respondent's argument. This is material on which it was open to the First Tier Tribunal to make that finding.
And you say that's sufficient to deal with the respondents. Right.
So in respect of the very significant obstacle test, in respect of what the respondent characterised as a failure to actually have the legal test of AM Zimbabwe in mind, yes.
Thank you.
Could I just
And in relation to families.
make sure I'm following this? Because this started off with our looking at suicide risk.
Yes.
And you were submitting, if I followed, that this is a case also of intense suffering, suggesting it was something distinct from the suicide risk. Was that what you were saying?
Yes, I mean.
So where is the intense suffering? Well, I've got two questions. Where is the intense suffering identified as something to be treated separately from the risk of suicide? And then secondly, if that was identified as a separate matter, did the judge in the First Tier Tribunal, Judge Davey, deal with it as a separate matter, separate from suicide risk? Or was he looking at it all in the round?
I wonder if I can address those questions when I come to the determination, which I hope to do so shortly.
Well, I'd just quite like to understand what your case is, as to what was it being said to the judge that was a risk of intense suffering and a rapid decline, different from suicide risk, given this all seems to be related to psychosis and to some extent drug-induced.
So the point about the distinction between intense suffering and suicide risk is that one only has to meet one aspect in order to show that that first threshold is reached, and the burden, if you like, then passes to the
Yes.
respondent. Perhaps I should take.
So the intense suffering is the psychosis and the risk that the condition will worsen, even if there is no suicide risk.
What we say is that the nature of the appellant's mental illness, so the way that he expresses it in his witness statement, the way that it is characterised by Miss Nonny, the support worker, and the way that it's expressed in terms of his symptoms, and the impact that it actually has on him by Dr. Day, that meets clearly the requirement for intense suffering. That was our case. And so what we say is that the respondent's submission that the judge did not grapple with the AM and Zimbabwe legal threshold, but would not, that the evidence before the judge, or rather the judge's reasons were not sufficient to show that the intense suffering requirement had been met.
Just say that again, the judge's reasons.
To show that intense suffering had not been met, were unfounded.
Or do you want to go back to the determination to show us that?
I wonder if I can just very briefly, just to square off the evidence, just take you to the country expert report.
Yes.
On the stigma point. So that's at page 113 of the supplementary bundle.
Thank you.
And at paragraph 19, 19.
Yes. Stigma and discrimination because of mental health.
Yes, I'm grateful.
Right. Shall we just read that?
I'm grateful.
Thank you. Right. And 20?
Just paragraph 19.
90. Okay, thank you. Right.
And so what that shows is that even if the appellant could access treatment on return, which we deny, the appellant would also face the general stigmatisation that affects mental health patients in Morocco.
But that, according to this report, 40% of the Moroccan population suffers or has suffered from a mental disorder. So 40%, up to 40% of the Moroccan population are also exposed to this stigma. Is that right?
Yes, my lady.
Right.
And mental health professionals also concur that stigma hampers access to treatment and their reintegration.
Right. So that's the evidence.
That
Now, can we go back to Judge Davey?
back to Judge Davey. Okay.
Right.
Thank you.
So, bearing in mind what the respondents' grounds are, they contended that inadequate reasons were provided for finding very significant obstacles in terms of family support on return. If you look at paragraph 8,
Yes.
examination,
Overwhelming evidence.
evidence was overwhelming. Not only was the appellant's mental health significantly impacted, it had significantly impacted upon his life in the UK, but he had been unwilling, effectively, or reluctant to seek out treatment. But the outcome now was that the appellant could take the necessary medication, could undergo treatment, and that there would likely be some improvement in his mental health. Unsupported, the likelihood was it was simply deteriorating. He did not believe he could have recourse to family members on the basis that they would not be interested in seeking help. Then go to paragraph 13.
I'm so sorry, this is my fault, Ms. Coe. What was the first paragraph?
The first paragraph is paragraph 8, Danny.
8. Thank you so much. My fault.
And then,
Paragraph 13, 1-3.
just a moment, do you want to look at 13?
Yeah, sorry. I'm
Just-
sorry, I'm behind the beat. Can I just catch up?
No,
My fault, I was writing
I
the
should
note.
wait.
Thank you.
Just checking all's well with the stenographer. All working all right? Good.
Right, thank you. Let's
So
go to
you
paragraph
wanted to take us to 13.
13, 1-3. I'm very able. And so the judge records the evidence, if you like, that is before him, and then turns to what the respondent has to say, if anything, about it.
Yes. I just note that we've passed over paragraph 12, which we looked at a moment ago, or a few minutes ago, which is the first reference to suicide. What Dr. Day said about suicide
It is, yes.
in the judgment. Okay. 13, and then the respondent's case. Where's that?
So the respondent, in very limited terms, addressed the matter.
Sorry.
Very
Oh, yes,
limited
there.
evidence in terms of the actual treatment available. There was no real examination of the medical evidence with reference to the exposure of the appellant to treatment contrary to Article 3. There was also no real assessment about cost of any treatment, whether it would in fact be available or accessible to the appellant. And what Judge Davies states is that the respondent's review and the respondent's evidence relied upon really did not get to grips with the issue, or why it simply thought support of his family would be sufficient, bearing in mind the evident need for psychiatric treatment in the UK and the availability and his willingness for mental health reasons in seeking treatment.
So the reference in the second line of paragraph 13 of Papashvili is to the decision of the Strasbourg Court, which led to the Supreme Court decision in AM Zimbabwe, isn't it?
Yeah.
I think what I say is that the judge clearly had that in mind.
Yeah. Yeah, I just wanted to check that I'm right in thinking that Yes, Mr. Denham is nodding vigorously. Thank you.
Right.
And then at paragraph 16, you see the reference to Dr. Day's conclusion.
Which we've been to already in the various points,
Yes,
that the 5 points that the judge extracts from Dr. Day.
And which he took into account.
Yes.
so in terms of family support on return, you
6
say
points, I
that
think,
the
actually.
judges, sorry,
Six.
Yes,
6 points.
Sorry, I think there are 6 points, aren't there?
Okay. Likelihood. Actually, 6 points is quite important, isn't it? Okay,
you
6
see
points.
that the judge's conclusion on that issue, in terms of the appellant's inability to actually access support on return, was in fact sufficiently reasoned. And then as regards the quality of available mental health treatment, the Judge Davey expressly referred to the appellant as being unlikely to seek out or access any available treatment. And we see that at paragraph 14. And so what we say is that the quality of the available treatment is therefore not to the point. Because if one cannot access
Sorry, the quality
the quality of any available treatment was not to the point.
would.
Not to the point, not relevant. Because if one cannot access that treatment, then the quality of it goes nowhere.
Could I just read paragraph 40 in full to myself again, in the light of your helpful discussion of the evidence?
Is this paragraph 14 on page 134?
Yeah,
The
In
second
other words,
paragraph, 14.
paragraph 19, in other words.
it's actually 80.
80.
It's 80. Do you see that? He's got the wrong
Yes, absolutely. It's the second paragraph.
second paragraph.
So there are
I'm calling it 18.
Paragraph
Yeah.
numbering problems in both determinations.
There are.
At
Curiously
roughly,
also,
at roughly the same
it
point.
was 17, wasn't it? There's the missing paragraph 17. Anyway, we know where we are. I'm going to read it now, if I may. Thank you. Right. So what's your submission?
So my submission in terms of intense stuffing, we've seen in my submission that that requirement was satisfied at the very least by Dr. Day's report, if not taken together with the appellant's witness statement, the evidence of the appellant's support worker. And reference is made by Judge Davey in the first or paragraph 14, actual paragraph 14, and paragraph 16, and then paragraph 18, as we now know it.
Yes.
Just dealing briefly with the other points. The lack of express reference. I mean, I think your Lord and Ladyship already have the point, but just for completeness, the lack of express reference to the public interest considerations in section 117B of the 2002 Act, we say is immaterial because of what is said at the new paragraph 18.
Right.
I take into account for obvious reasons the significance of maintaining effective immigration controls and public interest. And then just finally, I wanted to flag what was said by Lord Justice Hamblin in HA Iraq at paragraph 72.
Okay, so authorities bundle. Page 263.
Starts at 263. I'm good.
Which paragraph?
Paragraph 72.
72.
Great.
Yeah.
So just bearing in mind the context, the respondent's grounds of appeal, such as they were, the evidence, Judge Davies' determination, and then what is said by Lord Justice Hamden in HA is that it is well established that judicial caution and restraint is required when considering whether to set aside a decision of a specialist fact-finding tribunal. In particular, they alone are the judges of the facts. Their decisions should be respected unless it is quite clear that they have misdirected themselves in law. It is probable that in understanding and applying the law, which I say is clear, taking the decision as a whole, in their specialist field, the tribunal will have got it right. Appellate courts should not rush to find misdirection simply because they might have reached a different conclusion on the facts or expressed themselves differently. And then at subparagraph 2, where a relevant point is not expressly mentioned by the tribunal, the court should be slow to infer that it has not been taken into account. And then finally at subparagraph 3, when it comes to the reasons that are given by the tribunal, the court should exercise judicial restraint and should not assume that the tribunal misdirected itself just because every step in that reasoning is not fully set out.
Thank you.
Those are my submissions.
Well, can we come back to the question I asked you?
Yes, my lord.
If there is a problem, in looking at the relationship between paragraphs 12 and 16 as regards suicide risk, in the sense that they contradict each other, given that the judge keeps saying that he looks at things in the round and he moves almost imperceptibly between Article 3 and Article 8 and the immigration rules, can we see what you seem to be suggesting, namely that there's a freestanding basis for him to have upheld your client's appeal on human rights issues?
Yes.
Well, where do we
my
see
lord,
that?
in summary.
Where do we see it? Because that's what I've been waiting to hear.
I'm sorry, my lord. My response is that taking the determination as a whole,
Yeah.
and particularly the paragraphs I've referred to, I say that comes out quite clearly from the paragraph.
Yeah, well, I'm waiting for you to show us that.
Yes, I mean,
Because he keeps wrapping it all up.
Yes, I have to accept that. It's not explicit.
Right.
Despite Judge Smith having told the FTT that these matters were to be looked at separately.
Yes,
Because reading the First Tier Tribunal determination, one might have thought that he'd never read Upper Tribunal Judge Smith's determination, because it just doesn't seem to reflect the analysis in that decision. I mean, would you accept that?
I think that's a fair. I mean, one cannot know one way or the other. I think it's the only thing I can say.
Yeah, okay. Well, it's an unfair question to ask you, I think.
So, in the light of my lord's point, how do you say we should uphold or endorse the First Tier Tribunal's decision?
I say in essence that the respondent's application should have been dismissed. Obviously, we don't have reasons that were given by the Upper Tribunal in terms of that submission that was made, which is why we are now here today.
Do you want to say anything else about either tribunal decision?
I think I might leave the remainder of the points to Mr. Denholm, unless there is something on the respondent's application that the court wanted me to address.
Well, do you want to deal with that now?
I'm sorry. In terms of the next part of
What do you think? Hear Brown. I think we'll hear from Mr. Brown on your submissions now. Does that make sense to everybody?
By the way, yes.
Thank you very much, Mr. Cohen.
Mr. Brown, my lords and my lady. The Secretary of State's grounds of appeal weren't a quarrel with the evidence before the First Tier Tribunal. Ms. Cohen has shown this court some of the considerable volume of evidence before the tribunal. The Secretary of State's grounds of appeal, certainly as they were characterised when permission to proceed was given, was that they were criticisms about the quality of the First Tier Tribunal's explanation.
So this is paragraph 19 of the Upper Tribunal.
My lord, yes, and the grant which is quoted there,
Yes.
Core Bundle 111.
So it's the FTT's failure to explain properly why the appellant would not be supported adequately by his family.
So if one looks at page 111, Tribunal Judge Perkins says there are essentially 2 points.
Yes.
FTT didn't explain properly why the appellant would not be supported. Second, decision doesn't explain adequately how the appellant's poor mental health entitles him to remain on human rights grounds.
Yes. Now, one was Cohen has taken this court to evidence that was before the First Tier Tribunal, as has already been identified in part, and as I will just show, some of that evidence appears not to have been accepted by the First Tier Tribunal. So while it was evidence before the First Tier Tribunal, if it was either rejected or deflected, it certainly can't sustain the conclusions that the judge reached. The judge's finding at paragraph 12 of the decision in relation to suicide risk has already been addressed with my learned friend, and I won't go back to it. Page 133 of the core bundle, paragraph 15, the judge says it is really extremely difficult to assess the realities of the appellant in his current state being able to have recourse to such help in Morocco. It doesn't appear to be a clear finding that the appellant won't, but rather an expression of the difficulty of assessing it, the extreme difficulty of assessing it. Paragraph 13 of the judgment is or appears to be an observation as to the quality of the medical evidence. There are other problems in respect to paragraph 13, but the judge appears in essence to be expressing concern about the quality of the...
Well, he's talking about the lack of a response from your client. He's taken on board the material relied upon by the appellant.
Yes.
He's dealing with the AM point that if sufficient material is relied upon by a claimant, then the burden switches to the Secretary of State to deal with it.
Well, if he is...
So to say that there's uncertainty about that doesn't assist you.
Well, if he is, the problems with that paragraph is that the judge refers to the respondent's review, and the issue was not that the judge was not conducting a review of the respondent's Secretary of State's previous decision-making, but had to consider the evidence that was before the judge. So it's not clear why the judge is referring to the respondent's review, unless he thinks that the approach for him to take is to essentially review the quality of the Secretary of State's original decision-making. It's not the approach on a statutory appeal. But nowhere has the judge, to go back to the beginning of the decision, directed himself, even on the convention rights which were engaged. My lords, my lady, page 129 of the core bundle, the introduction to the appeal. The First Tier Tribunal judge identifies the human rights claim as one engaging Articles 2 and 3 of the Convention, says nothing about Article 8. The judge ultimately doesn't even determine an Article 2 complaint, having identified that as being one of the articles that the appeal raises, and says nothing there about Article 8 being one of the bases.
So that paragraph 1.
Paragraph 1, my lord.
Yes.
Third line on page 129. In the remainder of paragraph 1 over the page, the judge sets out the applicable burden and standard of proof and issues of fact relating to a protection claim. The appellant has the burden of proof of showing to that low standard identified in Siva Kumaran that he faces the real risk of persecution, and in facing it for a convention reason. That's a reference to the Refugee Convention, not the Human Rights Convention. And then what follows, alternatively, because of his mental health, he cannot have recourse to domestic protection in the Horvath sense. Again, that's a reference to mental health in the context of a protection claim.
So does that I'm so sorry to interrupt, Mr. Mann. Does that suggest that the FTT thought that the Article 3 claim was confined to a claim about persecution on the grounds of his mental health?
Well,
that would be supported by what the FTT says in what we're now referring to as paragraph 18.
Well, ultimately, the judge can't have thought that because he certainly didn't allow the appeal on Refugee Convention grounds.
No.
What is odd, though, is that the appeal is then allowed on Article 3 and Article 8 grounds with no reference in the introduction of the appeal to there being an Article 8 issue in the appeal. There clearly was an Article 8 issue in the appeal, but the judge doesn't refer to it. The judge doesn't refer there or anywhere either to the applicable standard and burden of proof in respect of as it were, a freestanding Article 3 claim, and in particular one which is based on access to health services. So there is no reference at all in the judge's decision to the words intense suffering. Well, it's right that the judge refers to Papashvili. That had been, in essence, explained by the Supreme Court in AM Zimbabwe.
Well, it's rather odd the way he refers to it, because he says if it's necessary to refer to it, why on earth shouldn't it be necessary?
Yes.
Maybe, unless he just thought it was all so obvious. I mean, he might have thought the principles were so obvious they didn't have to be set out.
But also, Papashvili isn't relevant unless and until there's a decision of a higher court here saying that Papashvili, rather than D, is the correct test. Yes. And so that's why when AM Zimbabwe was decided by the Court of Appeal, the Court of Appeal sort of said, oh, it doesn't really change anything.
Because previously it was dealt with by N.
Yeah.
Hmm.
So the judge hasn't referred to any of the domestic jurisprudence, and was, if he didn't refer to AM Zimbabwe, certainly by the time of his decision, because AM Zimbabwe had been determined, again, would have been approaching the matter wrongly in law. Albeit.
Can I just ask an idiot question? I mean, has the practice in the FTT changed so that the judges there typically do not refer to the articles separately and the relevant principles?
Well,
Conventionally, they always used to.
Well, my lord, that practice hasn't changed, and
That's reassuring.
The next difficulty for this decision is that there was a different standard of there was a different standard of proof in relation to the Article 8 claim, because that was to be determined on the normal civil standard. And as my lord and my lady will know, there is some complexity to the burden of proof in an Article 3 health case, because in essence it switches if a prima facie case is made out by the appellant.
And your point is none of this is covered in the judgment?
None of this is covered. Not only does the judge not refer to the intense suffering standard, and again, it's not intense suffering in isolation because of the careful formulation of the issue in Papashvili as adopted by the Supreme Court in Zimbabwe. Serious, rapid and irreversible decline resulting in intense suffering. From which
thank you, because one of the words mentioned there is irreversible.
Yes.
And it's not just the intense suffering that's not referred to, it's the irreversible. So in my simple way, I thought, well, presumably it's the suicide risk that's being relied upon as irreversible. But if there's some separate intense suffering case, not linked or not dependent on that, your point is that irreversibility has to be addressed specifically.
Yes.
Bearing in mind the high hurdle that applies to Article 3.
Yes. In addition to rapidity, the judge has got to consider in terms severity, rapidity, and irreversibility, and consider what consider factually what the consequences of that will be. And the approach for the First Tribunal to take is to consider whether the evidence establishes a prima facie case of that. And if so, then the burden switches to the Secretary of State to disprove that. The judge, it is very difficult to find in the First Tier Tribunal judge's reasoning any appreciation that that was the approach that the judge needed to take, other than by trying to infer that from some of the things that the judge has said. For example, the reference to Papashvili, subject to my lady's observations as to the status of Papashvili. But as I've said, in relation to Article 8, the judge had to reach findings on the civil standards, and nowhere in the decision do we see the judge saying, for example, well, in fact, I've made all of my decisions to the civil standards, and because I've reached findings at that standard, I don't need separately to worry about the distinct standards. Turning then to the Article 8 claim, this court doesn't have the litany of jurisprudence from both this court and the Supreme Court, but it is now established that the approach of the First Tier Tribunal ought first to be to consider whether an appellant meets the requirements of the immigration rules, because those rules set out the Secretary of State's immigration policy. And if an appellant meets the requirements of the immigration rules, that's the end of the matter, because the appellant has met the Secretary of State's policy. And it is only if an appellant does not meet the requirements of the immigration rules that there's a need to consider Article 8 separately.
And then isn't the starting point Part 5A of the 2002 Act?
My lady, yes. So, again, what we don't see is the First Tier Tribunal judge saying, having considered the following findings on the balance of probabilities, I've concluded that there would be very serious obstacles to the integration of the appellant were he to go to Morocco. So he meets the immigration rules and therefore the Article 8 appeal is allowed. Or conversely, I have concluded that he doesn't meet the test applicable under the immigration rules. That in itself is a factor that weighs against him because it means that he doesn't meet the Secretary of State's immigration policy. But here are the factors on the other side of the Article 8 balance sheet, which mean that it would be an unlawful interference in his Article 8 rights for him to be removed from the United Kingdom. And there, in my submission, GS India it is and remains good law. I think my learned friend had said that the observations of this court, so far as Article 8 was concerned, were obiter. My lords, my lady, at page 134 of the authorities bundle, we see that while this court held that Article 8 appeals had not been brought by 3 of the appellants, this is at paragraph 96 of Lord Justice Law's judgment, there was an Article 8 appeal in GM's case, and that was remitted to the Upper Tribunal for redetermination. And that is paragraphs 98 and 99 of Lord Justice Law's judgment. Equally, at paragraph 1 of the judgment, Lord Justice Laws refers to the appellants pursuing appeals or challenging removal decisions as being repugnant to their rights guaranteed by Articles 3 and 8. That's 109 of the authorities bundle, paragraph 1. So in my submission, because this was a decision, at least in relation to GM, and was essential reasoning in his case, the judgment of Lord Justice Laws
Not obiter.
was not obiter. In any event, as I've referred to in my skeleton argument, paragraph 18 on page 6, this court reconsidered whether GS was good law after Paposhvili was decided and held that GS India remained.
Remind us, say again where that is in the authorities.
Give me one. It is starts at page 151, and the relevant passage is at 157, paragraphs 27 to 28. Paragraph 28 in particular, Lord Justice Hickinbottom said, my firm view, the approach set out in MM Zimbabwe and GS India is unaltered by Paposhvili and is still appropriate. I do not consider the contrary as arguable. So, insofar as the Article 8...
I'm just going back to paragraph 22 of this judgment, that he specifically has cited 86 of GS.
Passage you just took us to, Lord Justice Law.
Yeah, yes.
And 87.
And so, insofar as there was a separate Article 8 claim, it was necessary for the First Tier Tribunal judge to be satisfied on the balance of probabilities. If this added anything, because if there was an Article 3 claim, then the appellant had succeeded on a human rights ground. But if this added anything, it was necessary for the First Tier Tribunal to consider whether there was some additional factor which fell within the paradigm of forming relationships or maintaining relationships. The overwhelming evidence which the First Tier Tribunal judge refers to at paragraph 8 of his decision is about the position of the appellant in the United Kingdom. The evidence was overwhelming that this is page 131 of the court bundle. The evidence was overwhelming that the appellant's mental health not only significantly impacted upon his life in the United Kingdom, but that the appellant had been unwilling effectively to seek assistance in the United Kingdom, or reluctant, if not unwilling, and further that these were plainly a variety of reasons for psychosis, including drug-induced causes. So this part of the judge's reasoning is not about overwhelming evidence of the situation were the appellant to be returned to Morocco. Again, the evidence that Ms. Cohen took this court to as to Dr. Davies' conclusions were he to be returned in that respect isn't something dealt with in paragraph 8 or in paragraph 16 where the judge says that he took into account Dr. Davies' conclusions. So in my respectful submission...
Sorry, just to interrupt for a
yes.
moment, please, Mr. Brown.
Yes.
Might it be said that the last bit of that sentence could be generalised to the position if the appellant were removed? Because Judge Davies says the outcome, which was that if the appellant taken this as blah, 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 there could be some improvement in his mental health, but unsupported, the likelihood was it would simply deteriorate.
Sorry, which paragraph were you reading?
I'm so sorry, it's paragraph 8. It's a very long sentence.
Yes.
It's the last bit of the first long sentence in paragraph 8. I'm just asking whether that last bit could be generalised to what would happen in Morocco.
It might be, my lady, that it could, and indeed that might be supported by the last sentence, the last 3 lines of paragraph 8, where the judge has gone into recourse to family. But again, having set out the appellant's evidence that he did not believe that he could have recourse to family members, including his mother in Morocco, the judge in paragraph 16 on 133, taking into account Dr. Day's 5th conclusion, says that the appellant's family may provide some supportive structure, but the appellant doesn't communicate his difficulties, nothing to indicate that they, over and above any ordinary person, are in a better position to provide help and protection from self-harm. And it's slightly difficult to know what the judge meant by that. Nobody was expecting his family members. The Secretary of State's case wasn't that his family members or themselves to be providing treatment or acting in some specialist way, but the question that followed for the judge was, why would somebody with their family, bearing in mind the applicable legal test, why would the appellant not receive sufficient support from his family members that a serious, rapid and irreversible decline in his state of health resulting in intense suffering would not be avoided? And in my submission, that question, if ever posed, is not answered by the First Tier Tribunal's reasons. The judge...
Just looking at 8 again, the evidence was overwhelming, not only as to his mental health and the impact upon his life in the UK,
Yes.
but it was overwhelming that he'd been unwilling, effectively, to seek assistance in the United Kingdom. There's hence the evidence that there was an unusual degree of support necessary, even to get him to take the medication.
Yes.
And in that long sentence, just reading it through, I'm not sure that the judge ever left the UK. He certainly does it in the last sentence. But he seems to be saying without the support that you have in the UK, the likelihood was that he would simply deteriorate. And then he goes to Morocco.
Yes, if that is the if that is what the judge is doing in paragraph 8, and one assumes from the opening words the evidence was overwhelming, or that the judge doesn't say it in terms that he is finding a fact, doesn't say to which standard of proof, but if he's saying it's overwhelming, one might, in his favour, not want to suggest it would be to the lower standard. But if that's the conclusion that the judge reaches, again, having taken into account Dr. Davies' conclusion that the appellant's family might provide some supportive structure, but it wouldn't be over and above what an ordinary person would provide. Again, in my submission, it leaves unanswered the question, what is it about not receiving family support in an ordinary way?
Well, thank you for raising that, because as I saw it, this was a point that Judge Smith was raising in his judgment. He was saying that if you look at the case of Kumara, it's a holistic assessment which is required, which looks at all aspects of life,
Yes.
not just the mental health issues and the ability to access services. And what I think he was saying about the first FTT's decision was it didn't really address the wider obstacles to life issues. In addition to the mental health issues, and where you might expect family support would be, why wouldn't the family support? Is that really where the Secretary of State was coming from in the appeal, that still wasn't being addressed?
My lord, yes. If the First Tier Tribunal judge had said, if the appellant were returned to Morocco, his family would shun him. He would arrive in Morocco. He'd have absolutely nobody.
Shun him in general.
Shun him in general.
Yes.
Then that would be relevant to the factual assessment of risk on return. But, of course, paragraph 16 of the First Tier Tribunal's decision is difficult its status is difficult to understand, because it says it's the taking into account of conclusions, but not making corresponding findings of fact.
Well, save that, to be fair to the judge, it rolls into 17 and 18.
It is, 18 is all rolled together, isn't
Yeah.
it? I mean,
Yes.
There's a thus at the beginning of 17.
Yes. The difficulty with that rolling up of it is, with the greatest of respect to the judges, it makes it difficult to understand, firstly, what legal questions the judge has asked. Secondly,
If this is an acceptable way of reasoning, it can be done by tribunal judges generally, where you've got Article 3 and Article 8 issues.
yes, it's the additional difficulty, if one looks at 14 bis or paragraph 18, is again, if one looks at, so maybe it's better to run in from paragraph 17. The judge says that he's looking at all the evidence in the round.
Paragraph 17 doesn't really reach any conclusions. It's just a kind of throwing stuff up in the air and saying, well.
Yes.
It's 14 bis or 18.
Yes. But
That is the key to it.
the judge refers to the relevance of integration. Well,
Yes.
integration is undoubtedly relevant because it's the question posed by paragraph
the
276 ADE
immigration rule,
of the immigration rules. But before the judge even begins to grapple with integration, the Article 3 appeal needs to be considered.
Yeah.
I mean, he considers them all together. In 18, he considers it, as my Lord said, rolls it all up. Right,
Yes.
so my Lord said it first of all, it is all rolled up.
And
The
then,
question is whether one can extract a clear line of reasoning on all the points from the roll up. And you say we can't.
Or perhaps you can extract a sufficient line of reasoning on an independent, freestanding basis to justify upholding the human rights claim.
well, it might be there. It might be there that Jaffrey does come into play.
Yeah.
Because if in essence a first tier tribunal might, on the evidence, be able to reach a decision.
No, forgive me. The question is whether this FTT did,
Yes.
not whether it might.
Yes. But then if
And which we can only judge from the reasoning expressed.
yes, yes,
So should we look at 18?
yes. What the judge, the basis for the judge's allowing the Article 3 appeal is that there is a real risk of Article 3 ill treatment, either arising through societal discrimination. Well, that isn't the AM Zimbabwe test, and it's not clear what societal discrimination the judge has in mind that would meet the minimum threshold of severity to constitute inhuman and degrading treatment.
The stigma is not enough.
It falls very far short of constituting Article 3 ill treatment.
Could you forgive me for interrupting? Could you just tell us and give us a source for what is the threshold under Article 3 for societal discrimination? Because I think you're saying it's not in AM.
No. What I was going to... The authorities bundle will undoubtedly refer many times to the so in GS India, page 116 of the authorities bundle, paragraph 39, Lord Justice Laws says, as regards Article 3, Strasbourg Court has repeated time without number that to fall within the scope of Article 3, the ill treatment must attain a minimum level of severity. So that is...
Does he say what it is?
Well, no.
So that doesn't answer my Lord's question.
But just be helpful is to have a pithy...
Yes. Well, I have to say, I'm not aware of freestanding societal discrimination.
No, but I think what you're saying is that there is a minimum level of risk, which, be it societal discrimination or something else, you have to show. So how is that encapsulated?
Well, my lord, I'm not sure whether it is. I mean, while the health cases have produced a legal test which falls within the penumbra of Article 3, I'm not sure whether societal discrimination cases have.
It doesn't seem plausible when you consider how demanding the threshold is in Papashvili and AM Zimbabwe.
It would certainly have to be treatment that reached
A minimum level of severity.
level of severity.
And the passage we were taken to in the evidence that was before the FTT said 40% of people in Morocco suffer or have suffered from mental illness, and they're all experiencing stigma. I mean, they can't all be suffering Article 3 ill treatment, can they?
What Lord Justice Laws says in the same paragraph of GS India is that the language of Article 3 shows that the paradigm cases of a violation is an intentional act which constitutes torture or inhuman or degrading treatment or punishment. So that's the starting paradigm of Article 3, is that it's intentional conduct. So of course there might be, there will be treatment, it might well be of exactly the same sort as treatment which would be protected under the Refugee Convention.
So the medical cases are an extension of that approach.
Yes. And of course the medical cases are dealing with the state's positive obligations, because nobody is suggesting that the state is inflicting intentional acts which constitute inhuman or degrading treatment, but it is one branch of the state's positive obligations in the same way that the Strasbourg jurisprudence, in essence, by way of a positive obligation, prevents states from returning people to countries which will leave them languishing on death row for decades.
I mean, looking at the Judge Davies' judgment, trying to track back from his conclusion about Article 3 and 18, New 18.
Yes.
Societal discrimination is mentioned in 14.
Yes.
I think that's, and then we go back again to 13, where he refers to the CPIO measure. That's the passage we've looked at earlier, is it?
Yes.
Then he criticises the respondent for not addressing that.
Yes.
And that's it, isn't it?
Well, we'd left off with the word societal discrimination in paragraph 14, second paragraph 14 and 1 through 4.
All through the state in its
All through the state in its treatment of him. So that's suggesting that there would be persecution.
Yes.
And I think there's an earlier reference to his being questioned on his return. So I wonder whether that's what he's getting at.
That's paragraph 12 on page 132. The judge says, manifestly obvious, that the security services necessarily would detain and further question with the associated difficulties identified in the medical evidence of Dr. Day.
And then at the end of the paragraph, but sufficient to say his mental health would be an indicator of greater vulnerability if subject to pressing examination by the security forces on a return to Morocco.
If.
Yeah.
But again, questioning by a state agents is not in and of itself Article 3 ill treatment, and so the judge would have had to conclude. And
I think there's a suggestion in the papers that his difficulty in responding to questions because of his mental ill health would then lead to detention and further adverse consequences.
Yes,
there's a sort of blurring almost of discrimination and persecution.
Now, it's 1 o'clock. I mean, you've covered this point, haven't you, really?
Yes.
Are you going to say anything? Miss Cohen took us to the grounds. Your grounds to the UT, and you're content with that she identified 3 grounds of appeal. You're content with the way she did that? This is page 125.
Yes, I think
it's really. To me, you might think that she'd been a bit reductive about that. But essentially, your point is that there are inadequate reasons for finding.
Well, I think Mr. Brown accepted that Upper Tribunal Judge Perkins' calculation of the grounds of appeal and the grounds of permission.
Oh yes, so you did. So
perhaps
19.
Yes.
Yeah.
Perhaps the
all right. Well, let's leave it there.
Yes, I was going to say perhaps only the important distinction between my learned friend Ms. Cohen's characterisation of my grounds of appeal and my own characterisation. Ms. Cohen says in essence that the Secretary of State is saying that there was insufficient evidence.
Yes, you've not focused on the evidence.
And I say this is not about the evidence at all.
It's about the reasons.
It's about the reasons. Yeah. But in any event, some of the evidence that Ms. Cohen took this court to in fact, is not dealt with by the First Tier Tribunal judge in support of the appellant.
No.
And I think, as I'm saying, you talk about the reasons sufficient to show that the correct legal tests were being applied,
My lord, yes.
particularly in the face of the earlier grounds of appeal within the tribunal system and Judge Smith's decision.
Yeah.
Can I just ask one quick question? The paragraphs 12 and 15 and the suicide risk.
16.
16, I beg your pardon. Are you saying anything about what might appear to be a contradiction between the two?
My lord, yes. I mean, there is in my submission a contradiction between them. And given the judge's ultimate conclusions on page 134, his characterisation of the Article 3 ill treatment, which is leading him to allow the appeal on Article 3 grounds as being societal discrimination and through the state in its treatment of him, well, neither of those suggest that the judge is identifying suicide risk as the Article 3 treatment. Indeed, neither of them suggest that the judge is identifying insufficiency of medical evidence or lack of access to medical evidence per se as the reason.
So neither suggests he's applying the correct test.
And neither suggests that he's asked or applied the correct test either in relation to a medical case or in relation to a non-medical case. And then in relation to the Article 8 claim, nowhere does the judge first ask, does the appellant meet the applicable requirements of the immigration rules? Where the appellant's clear case was that he did. And only go on to consider Article 8 outside the rules in light of the assessment on the first stage, again, having regard to a difference in the burden of proof.
Right, it's now gone 1 o'clock. How are you? Have you said what else do you want to say?
My lord, I anticipate I've said as much as I would want to, subject to any further questions from the court.
All right. So when we go back to Mr. Denham, do we? In reply?
My lord, I think
Not now, but at 2 o'clock.
yes. I had assumed and I think this, I suspect my learned friend and I are both very much in the court's hands on this, but at the next stage, well, I think Ms. Curran can reply to what my learned friend has said
Yes.
about the first tier determination, if she wishes to. I think the next point that then arises is my learned friend's powers point, if that's still pursued in light of everything else that's happened.
All right. Well, I think what we'd like from you, please, we'd like you to talk between yourselves about this over the adjournment and come back with a clear route map for where we go from here in terms of the hearing, because it's quite confusing, but I'm sure you can work it out for yourselves. Thank you very much. We'll come back at 2:05. Thank you. 2:05.